Hey guys, Todd Vandermeid back for another edition of Freedom Steel, and we've got just a quick update on things surrounding the Illinois gun ban and things that could impact that coming up right after the intro. All right, everybody, Todd Vandermeid back for another edition of Freedom Steel, former NRA contract lobbyist, Illinois gun law guru, gun Santa or tactical Santa, as some people like to call me around on Reddit. So, a couple of things. So, we have the briefs, the final briefs and arguments due by both sides on October 21st, just 11 short days from now. The final briefs will be due in the case to the trial judge, Judge McGlynn, summing up our arguments of law and the like. We have that. Now, you also have Viramontes, the challenge to the Cook County semi-auto ban, going up for oral arguments at the 7th Circuit Court of Appeals on November 12th. All right, so a couple weeks after our briefs are due, Viramontes is up on oral arguments in front of the court. Unlike some other districts, we don't get to see the panel ahead of time. So the question is, will Easterbrook and Woods claim this as a comeback case related to the Southern Illinois and Beavis case? Will we draw a new panel? If we draw a new panel in that case, will Easterbrook finagle his way and manipulate the system to get on that panel? What does this look like? We don't know. I'm not a particular fan of the Viramontes case because it doesn't have an in-depth record to address and attack the things that Frivolous Frank and his cohort, Justice Wood, put into the Beavis preliminary injunction ruling. So there's that. Now let's jump over to what we used to call Bianchi. It is now Snope. Mr. Bianchi has exited the case. David Snope is now the lead plaintiff in the challenge to the Maryland semi-auto ban. And so earlier this month, let me get over to the Supreme Court docket here. So, October 21. Petition for writ of certiorari is filed by the plaintiffs in this case. September 11th, a couple weeks later, the state asks for a 30-day extension from September 23rd to October 23rd. So they get that. Here we are yesterday. The state files a letter for a motion requesting another extension, another 30-day extension, when this had already been slated for conference to go up on conference in November. And late yesterday, the plaintiffs responded to this. And remember when I said this thing all started out, my question was one of two things. Will the state of Maryland sit there and refuse to respond, having the Supreme Court tell them they needed to respond as a stall tactic? Or would they simply keep asking for more time extensions? And the latter is what they're doing. They're asking for a longer extension to drag this out. And I think David Thompson from Cooper and Kirk expertly recognizes what is going on in this case. And so I'm going to quote the letter to you. In recognition of the importance of this case, in desiring an opportunity to present the issue to the court this term, we filed the petition for a writ of certiorari just 15 days after the Fourth Circuit issued the decision below. As the deadlines in this case currently stand, and after respondents already received an initial 30-day extension to which we did not object, this case will be distributed on November 6, 2024, and will be considered by the court for the first time at the November 22-24 conference. with just 3 conferences remaining before the end of the year. A 30-day extension would mean that this court would not consider the case at conference until January 10th, 2025. So that's the delaying game, because that would push us into January, which means if they would have to calendar the case fairly quickly, we might get orals in March, more than likely April, and then will be one of the last decisions that come out right before July 1st. So he goes on, he said, if the court is inclined to grant any extension at all, it should not delay the case more than 13 days to permit this case to be distributed on November 19th, 2024 for consideration at the December 6th conference. So they're attuned to what the state is trying to do. And the question now becomes, in the Illinois case, how soon does Judge McGlynn get a ruling out? Does Judge McGlynn get hamstrung because you have orals and Viramontes on the 12th of November? If Frivolous Frank gets on that panel and they do what was done in the Beavis injunction ruling, and then do they try to push down a ruling that then ties the hands of Judge McGlynn? I think it would behoove Judge McGlynn to get the briefs and start, get a decision out there quickly. We would also hope that Judge McGlynn doesn't stay his decision, and we've got a lot of people out there who were buying guns, in the process of buying guns, when the 7th issued their stay, and it would be nice to have a Freedom Weekend. I mean, it would just be all too cool for him to drop his decision at, say, 4:37 on a Friday afternoon, right in front of the weekend, and then we get Freedom Weekend at the minimum before the 7th puts their big thumbprint down and tries to issue a stay. But anyways, so we've got that. The other question is now, obviously, Judge McGlynn has a chance to get a decision out if we are not going to be considered in Snope for conference until potentially December 6th, which would mean that there's ample time to get a decision out. Question is, does the 7th Circuit in Viramontes come up with a decision quickly? Remember, they've still relied on Friedman with Frivolous Frank and that piece of garbage he wrote umpteen years ago. And then they doubled down with Beavis saying, nah, more of the same. So is this a case where they just regurgitate what was in the Beavis opinion on the injunctions and the injunctions down south, and just regurgitate that in a final decision quickly in order to try to hamstring Judge McGlynn? I hope not. But I do not put anything past, Frankie Easterbrook. I think he's dealing from the bottom of the deck. I think that he doesn't like this issue. He wants to prove how smart he is, and he's smarter than everybody else, including Clarence Thomas. But the question is, after Clarence Thomas issued that invitation saying, if you continue to uphold this, he relishes the chance. So the question is, what's bigger? Is Easterbrook's ego bigger, and that I'm going to write something and dare them to overturn me or say something else? Or is he willing to say, yeah, maybe I don't need a complete smackdown from Clarence Thomas, who I believe Easterbrook considers his intellectual inferior. I think Easterbrook's ego outshines his waistline, and it's just that much bigger. I'm not sure how he gets through the doors at the courtroom in the morning with an ego that big. But those are the things that are in play right now for the Illinois gun ban. Everybody keeps asking what's going on. So the next deadline for us is the 21st of October, followed up then by oral arguments on Viramontes on the 12th of November, as we wait and see what's going to happen with the former Bianchi case, now known as Snope. So That's it in a nutshell, ladies and gentlemen. So, as always, thank you very much for paying attention. Like, subscribe, copy and paste the link and share it around on social media to all your friends. And we really appreciate all the support and everything. And I'll have a couple updates on my wife and another video on Vanderstock coming up. I've got some other thoughts about it. But as always, frag out.